We're continuing to talk about federal courts, and this second video for weeks 5 to 6 deals with something known as removal jurisdiction. And so first I'm going to identify removal jurisdiction, and then I'll put up a couple of examples on the screen after we do this sort of preliminary observation. So as I have here in the textual outline, page 12, removal jurisdiction occurs when we have a case that originates in state court. And under certain circumstances, that case, which is now in state court, can be removed by the defendant to federal court. And I say if there's an independent ground for federal subject matter jurisdiction, and if that independent ground is diversity, the defendant must be a citizen of a state other than the one in which the case is pending. But let's just appreciate the fact that we may have a case in state court properly brought there, and the defendant, and of course it's the plaintiff who brings the case there, the defendant sometimes will have the choice of removing that case to federal court. So we want to get comfortable with this idea, because if you work in a firm that does civil litigation and there's a fair number of cases that the firm is dealing with, you're going to see this happen from time to time. And again, the examples will give us a greater sense of this. And by the way, the process or procedure for removal really just involves filing papers in federal court and state court, and the case then goes to federal court. So the procedure is not a big deal, but understanding the concept is a big deal. So let me just pause this for a second and we'll put something else up on the screen. So I have up on the screen now two different examples for removal jurisdiction. And by the way, I will also post these examples after this, so they'll appear after this video, and you could print them out or however you are handling the documents. But in any event, and by the way, both of these are cases that actually happened, and I had the fortune, I don't know whether it was good or bad, to be involved in them as an attorney. So case number one, plaintiff is a New York company, and it sues a defendant company corporation from Texas, and it was a breach of contract case. The claim was about $300,000. Contract law is state law, and so the plaintiff was claiming that the defendant breached a contract it had with plaintiff, and plaintiff was damaged for approximately $300,000. And actually, this was a construction project in the city of Niagara Falls. This goes way back to the 1980s, I believe. In any event, the plaintiff's attorney sues the case in New York State Supreme Court. Venue is Niagara County, which was proper because that's where the plaintiff company was, etc. What happens, though, is the defendant doesn't want the case in New York State Court. The defendant wants the case in federal court. And it removes the case to federal court. And how can it do so? Because there was an independent ground for federal jurisdiction, namely diversity. So you've got diversity jurisdiction, plaintiff New York, defendant Texas, claim in excess of $75,000. And the twist, or I shouldn't say twist, but there's a wrinkle, the defendant must be from out of state for there to be removal if there is removal based on diversity jurisdiction. Well, the defendant Texas was sued in a court out of state, namely New York, and therefore it could remove the case to federal court. Now, you may ask, well, why did the defendant feel the need to do that? and it was a judgment call on the part of the attorney for the defendant. I remember talking to that attorney on that occasion. Just out of curiosity, I asked the attorney why, and the reply was his clients felt uncomfortable with the case in New York State Supreme Court, Niagara County, believing that possibly the plaintiff company had political ties, etc., which could have prejudiced the defendant corporation had the case remained in state court. I think that was a reasonable understanding of the situation, and it wasn't an exercise of paranoia. And on the other hand, I would say that there was really no concern that there was corruption per se, but certainly a claim for concern. So the defendant, Texas Corporation, removed the case to federal court. It was removed to the U.S. District Court for the Western District of New York, and there the parties proceeded with their litigation. The second example, here we go, is another case that was sued in New York State Supreme Court, Niagara County. And we have a plaintiff who, and I'll tell you a little bit about the case, but our plaintiff is from New York and our defendant is from New York because it's a New York school district. And the claim arose not under state law, so we don't have to worry about diversity. It arose under federal law. And what happens is the plaintiff was a school teacher in this school district, and the school district exercised its rights to bring a proceeding against the plaintiff to remove the plaintiff from employment on the ground that the plaintiff was a teacher and the teacher had done engaged in misconduct. We don't need to get into what that was all about. But while that proceeding, which was an administrative proceeding, was going on, the plaintiff hires a lawyer and sues the school district. And the argument was this. The school teacher, before the proceeding was brought to terminate the teacher's employment, was at a school board meeting and made several remarks that were not complimentary to the school district or the school board. So the plaintiff was claiming, I never thought there was much merit in it, and it turned out to be that was the result. But the plaintiff was claiming that the school district was seeking to terminate the plaintiff's employment to punish the plaintiff for the remarks the plaintiff made at the school board meeting. And there's a federal law, and it's found in Volume 42 of the United States Code, Section 1983, and it essentially claims that, provides that if a state government or a subdivision of a state, in this case a school district, has punished someone for an exercise of constitutionally protected rights, in this case the First Amendment, then the person so punished can seek relief under that law. Now, the plaintiff could have brought the case in federal court, but the plaintiff's lawyer, for reasons still unknown to me, really elected to bring the case in state court. That was permissible. Go back to, I think it's page 11, footnote 1 of the textual handout, and you'll see that federal claims, except for a few, can also be brought in state court, and that's what the plaintiff's lawyer did. I was representing the school district, and I wasn't comfortable with the case in state court. It had nothing to do with concerns about local interest or anything like that. I just felt that it was a kind of case that came into the district court frequently, and that a district court judge would be perhaps better prepared to address the legal issues, and I felt that the legal issues were strongly going to lead to a conclusion that the case should be thrown out. Eventually it was. But what I did, because there was a basis for federal jurisdiction, namely federal question jurisdiction, I was able to remove the case to federal court, and that's where it went. So, again, removal jurisdiction is where we've got a case in state court, but there's a basis for federal subject matter jurisdiction. And if it's a federal question case, the defendant can move it to federal court. If it's a diversity case, then if the defendant is from out of state, then the case can be removed to federal court. So this gives us two actual examples of removal jurisdiction. And we'll stop the video at this point.